Okay, I want to talk about proportionality and law. Proportionality has to do with, does the punishment fit the crime? So if I get a parking ticket, does that parking ticket escalate to the Queen? If I steal a pack of gum from Shoppers Drug Mart, do I end up going to jail? A lot of it depends on my circumstances. It depends on my age. It depends on a lot of things. So in Julian Assange's case, he had sex with women in Sweden in 2010. There were different versions of events of what happened in Sweden. And in fact, Sweden was caught cutting and pasting versions of even the women's testimony in police reports and signing a signature to Sophia Weiland's report that she refused to sign. So anyway, Assange winds up in Britain. He ends up surrendering to the police because his name is associated with major sexual assault in Britain. And he trusts the British system, which in hindsight he shouldn't have. So the situation never escalated to charges. It was always allegations. In the meantime, after December 2010 up until today, the European arrest warrant was challenged in British courts to say that, okay, this is not proportionate. I haven't been charged with any crime and I haven't had a chance to defend myself. There's false evidence circulating in Sweden. I haven't seen exculpatory evidence that could prima facie make it a dead case and without basis. And up until that point, he'd seen documents in Swedish, not in English. Further, there were various ways to advance a preliminary investigation that Sweden could have done and refused to do, even though I had used video conferencing and phone calls and interviewing suspects in other countries. It chose not to do that in the Assange case. So fundamentally, the question of proportionality is at the basis of what my article is about. So if you have a European arrest warrant for somebody who hasn't been charged, Britain changed its laws to exclude that person from being extraditable. So if the European arrest warrant wouldn't be deemed valid because it would be disproportionate to extradite somebody who only has allegations against them but no charges. So in 2014, the extradition law in Britain was changed, but then at the end of that law revision, there was a clause that said it will not be applied retrospectively. So the bottom line is that Assange and his lawyers challenged the proportionality of the extradition law right up to the Supreme Court, and he lost. But if you look at 336 emails that are in this article, medium.com, Jude Fleming, and you'll see the link. I'll put this on my Twitter feed. The 336-page emails show the evolution of who is speaking with whom, what they're discussing, and who's going to attend the hearings, who's not going to attend the hearings. And it basically describes how there was a stack of pending extradition cases that were being held in abeyance, and Julian's case was put at the bottom of the stack. So if you think of a card dealer in a casino, or if you think of a magician that plants a card, let's just call Assange's case the Ace of Spades, they put him at the bottom of the stack of cards. And so a case would come up, it would be presented to the Supreme Court and then held in abeyance. And another case would come up, it wouldn't be decided on, it would be held in abeyance. Why? Because they were waiting for the extradition law to be challenged and decided upon so that once it was decided upon, voila, Assange's case would come up and he would be rejected for benefiting from the revised extradition law. And that's why I call it the Assange exclusion clause. So it shows in this email dated March the 9th, 2012, Paul Close, the British Crown Prosecution Service lawyer, speaking with Marianne Nye, who is the Swedish prosecutor, saying that, okay, here's an agenda for today's meeting regarding the Supreme Court judgment in Assange case. They were deciding whether the European arrest warrant, the EAW, was valid or not. So Paul Close says, my colleague, blank, has kindly tried to flush out some information from the Supreme Court about possible dates for the final decision, which ended up being May the 30th, 2012. And that's when Assange's legal remedies for challenging the extradition warrant were exhausted. His response is below. So Paul Close copies and pastes the response he got from somebody who was talking to the Supreme Court. Quote, my best guess is next month, which would have been April 2012, and ended up being May. As always, I will be in touch as soon as I have news. The concern of other agencies here in the UK, such as the Home Office and SOCA, Special Organized Crime, I can't remember what the A stands for, is that there is now a large backlog, think of a stack of cards, of extradition cases which are in abeyance. They're being diverted and held back, pending the outcome of Assange. However, I cannot stress enough that it is the UK system and law which are in issue, and most definitely not the Swedish ones. So Paul Close is saying that Sweden's legal system is not under the microscope. Britain's system is. So the short version is that Assange challenged the proportionality of the extradition law in Britain. Then the old law, which was disproportionate, was revoked and replaced with a revised law in 2014. While that challenge was in court, the Crown Prosecution Service held back a large backlog of cases, and they use the word scores in that 336-page document, in abeyance, then let those persons benefit from the revised law, but not Assange. It was not applicable retrospectively. So the obvious solution now that this has come out into the open, would be to apply the new law to Assange retrospectively, because his case should have come up and been dismissed just as the other backlog of cases was. But clearly from these emails, the British Supreme Court was weaponized to incapacitate Assange, in particular with prejudice, strategically, and that's led to his current torture, arbitrary detention, which the UK denies and has called the UN ridiculous in calling it arbitrary detention. The UN has every right now to say, this is arbitrary detention. We have proof that it was arbitrary detention because you stacked the deck. It was rigged. It was, this wasn't standard operating procedures. The law wasn't applied consistently. And these tactics must have been orchestrated at the highest level of government, because you can't get away with this without a lot of high-level maneuverings. So in another email, page 223, Paul Close says, I should mention that the certified legal point has potentially far-reaching consequences for scores of pending cases from, in particular, Estonia, Lithuania, Netherlands, Belgium, and Greece. So that was on page 223. And then if you go back into an email that was January 24th, 2012, it talks about how, and it's very specific, quote, Paul Close is saying, the SC, which is the Supreme Court, the Supreme Court will know that the outcome of the challenge to the proportionality of the extradition law, the Supreme Court will know that the outcome will have an impact on numerous current pending European arrest warrant cases, no matter what. Cases are being adjourned regularly pending the outcome in Assange. So it doesn't get any more clear than that.